One of you is going to do this alone, not because anything is wrong, because that's how it works. Two people, and one of them goes first. Everybody knows this, and almost nobody plans for it. And here's what makes the difference between a hard year and a hard year with a locked bank account on top of it. Almost everything that protects the person left behind has to be done while you're both still here. Not in a will, not afterwards. Now on an ordinary afternoon, when it feels completely unnecessary. Nobody sends a letter about this either. Here's why this catches couples who have been careful their whole lives. Most people over 60 have done the thing they were told to do. They made a will. And a will is a real document that does a real job. But it does that job after death, through a legal process, and it has nothing to say about the 12 months in between. Meanwhile, in almost every couple I've ever heard described, one person handles the money. Not out of secrecy, out of division of labor. One does the accounts and the insurance and the passwords. The other does other things for 40 years, and it works perfectly. Until the person who handles it is the one who goes first. And then the survivor isn't just grieving. They're trying to work out what exists, where it is, and who to call, with no map at the worst possible moment. That's not a legal problem. It's an access problem, and a will doesn't touch it. Today, we're following three couples through the same event and watching what separates them. All three loved each other. Only one of them made the afternoon. One thing before we start. I'm not your advisor, and I'm not an attorney, and the rules here vary a great deal by state. How accounts are titled, what has to go through a court process, what a surviving spouse is entitled to. What follows is how the mechanism works, not what you should do. This is genuinely a subject to take to somebody licensed where you live. Bill and June. Bill has always handled the money. Every account, every policy, every password. June knows they're fine because Bill says they're fine, and Bill has never been wrong about it in 41 years. Bill is not hiding anything. Bill is doing a job he's good at, the way he always has. Clifford and Rose. 10 years ago, they spent one afternoon on paperwork neither of them wanted to do. They checked how each account was titled. They read every beneficiary form out loud. They made a list of what exists and where, and they both know where the list is. Nothing happened for a decade. Clifford brought it up twice at dinner parties and people changed the subject. And Emmett and Nadine, who did half of it. They updated their will 3 years ago with an attorney. Properly, thoughtfully, and it cost real money. What they didn't do is look at the beneficiary forms on the retirement accounts, because nobody told them those were a separate thing. Their will is immaculate. It is also, for the largest accounts they own, not the document that decides. Here's the mechanism, and it's the one thing I most want you to leave with. Retirement accounts and life insurance don't pass through a will. They pass by beneficiary designation, the form you filled in when you opened the account, possibly decades ago. When the form and the will disagree, the form generally wins. Not because anyone is being clever, because that's what the form is for. Now, most conversations about this jump straight to who inherits what. I want to spend time somewhere else first, because it's the part that actually hurts in the early months. An account titled in one person's name is that person's account, not the household's, not the couple's. When that person dies, the account doesn't quietly transfer to the spouse because they were married for 40 years and the bills come to the same address. It generally has to go through a process before anyone can touch it. That process takes time. And I'm deliberately not going to tell you how long, because it depends entirely on your state and your circumstances, and anyone who gives you a single number is guessing. But here's what happens in the meantime. The bills don't pause. The mortgage, the utilities, the insurance, the property taxes. They arrive on schedule into a household that has just lost income and may not be able to reach some of its own money. Read that again, because this is the scenario that turns grief into a crisis. Not poverty, illiquidity. Money that exists on paper in an account nobody can currently open. Bill and June have most of their savings and accounts in Bill's name because Bill set them up and Bill managed them, and there was never a reason to change it. Clifford and Rose looked at exactly this 10 years ago and changed what needed changing. There's a second half to the access problem, and it's not legal at all. June doesn't know what exists, not the amounts, the accounts themselves, which bank, which insurer, whether there's a small pension from a job in the 80s, whether that life insurance policy is still in force or lapsed in 2003, where the deed is. And this is genuinely common, and it is nobody's fault. It's what 40 years of a sensible division of labor produces. The version of this that upsets me most is the policy nobody claims, a real benefit sitting with an insurer, unclaimed for years, because the person who knew about it was the person who died. There's a version of the access problem that didn't exist when most of you set your finances up, and it has quietly become the biggest one. Everything is behind a login now. 20 years ago, if your husband died, envelopes kept arriving. A statement from the bank, a notice from the insurer, a letter about a pension. The mail told you what existed. You didn't need a list because the list arrived, a piece at a time, whether you asked for it or not. Then everybody went paperless. Sensibly. It saves trees and it stops the mail piling up. And now, when somebody dies, nothing arrives. The accounts are still there. The statements are still being issued. They're going to an email address the survivor can't open, about accounts they don't know exist. Read that again, because it's genuinely new and nobody has adjusted to it. Going paperless quietly deleted the safety net that used to catch the surviving spouse. And it gets more tangled. Most accounts now need a code sent to a phone. That phone belongs to the person who died. If the service is canceled, which families do quickly because it feels like the tidy thing, the codes stop arriving, and the accounts become genuinely difficult to reach even for someone entitled to them. The email account is the master key because it's the recovery route for everything else. And email providers have their own processes for a deceased user's account, which are not fast and not simple. So here's the small, unglamorous, enormously valuable thing. The list has to include the digital doors, not just the money. Which email address the statements go to, which phone gets the codes, how to get into that phone. And one very practical instruction, which sounds trivial and is not. Do not cancel the phone line quickly. Keep it running for a while. It is the key to a lot of doors. Let's talk about the costs that don't look like costs. The first is the income drop. When one spouse dies, the household stops receiving one of the two Social Security benefits. The survivor keeps the larger of the two, which is a real protection and worth knowing about, but the smaller one stops. So the household income falls permanently in the same month everything else happens. The second is the filing status, and this is the one that feels genuinely unfair. For the year of the death, there's usually some continuity. After that, the survivor generally files alone rather than jointly. And the brackets for a single filer are narrower than for a couple, which produces the outcome I want you to hold on to. Less income coming in, and the same income taxed less favorably. Both at once, arriving on a delay in the second year, when everyone has stopped checking on the survivor and assumes things have settled. And there's a third, which we covered on this channel a few days ago, and which I'll only mention. That changed filing status can also move a survivor across a line for their Medicare premium. Same person, less money, higher bill. None of these is a penalty. Every one of them is a system doing exactly what it says it does. They just all happen to the same person in the same year. But hold that thought, because the most avoidable thing in this entire video hasn't happened yet, and it happens to Emmett and Nadine, the couple who did the expensive part right. Bill dies. June is 76. Within 2 weeks, she's dealing with a bank that won't discuss an account she isn't on, an insurer she isn't sure exists, and a filing cabinet she has never opened. She is not incapable. She raised 3 children and ran a household for 4 decades. She simply doesn't have the information, and the person who had it is gone. Her children help. One of them lives 4 states away and has opinions. Another takes 2 weeks off work, and every one of them is doing this while grieving, which is when human beings make their worst decisions. Nothing here was caused by a mistake. It was caused by an afternoon that never happened. Clifford dies the same year. Rose knows what exists, because there's a list. The accounts she needs are ones she can already access, because they check the titling. The beneficiary forms say what they intended, because they read them out loud 10 years ago and found 2 that were wrong. Rose's year is still terrible. Nothing about that afternoon made her less sad. What it did was stop the sadness from being joined by a bank, a court, and a filing cabinet. That's the whole benefit. It isn't money. It's the absence of a second disaster. And Emmett dies, with a beautifully drafted will that leaves everything to Nadine. The largest retirement account he owned has a beneficiary form from 1991, filled in at a job he left in 1996, naming his brother. The brother is a decent man. He is also, on paper, the beneficiary. And what happens next depends on the plan's rules, the state, and whether a decent man wants to spend a year unwinding something that a form says is his. This is the part that breaks people's brains. Emmett paid an attorney. Emmett did the responsible thing. And the document that decided the biggest account wasn't the one he paid for. So let's take Emmett's situation apart, because it's the most avoidable failure in this entire subject, and it costs nothing to prevent. Beneficiary forms are not one document. They are many, and they live in different places. Every retirement account from every employer you've ever had. Every account you rolled over, and the rollover may not have carried the old designation with it. Every life insurance policy, including small ones, through an employer that people forget they have. Every annuity. Each one was filled in on a different day, in a different decade, in a different life. Nobody reviews them because nobody tells you they're reviewable. And here's the second layer, the contingent beneficiary. That's who receives it if the primary beneficiary has already died. Most forms have that line blank because it felt hypothetical at the time. If it's blank and the primary is gone, the account can fall back to the plan's default rules, which may be nothing like what you'd have chosen and which nobody in your family will be able to argue with. The fix is genuinely free and takes an afternoon. Log in or call. Read what each one currently says out loud to the person it concerns. Name a contingent on every single one. Clifford and Rose found 2 wrong ones doing exactly this. 2. In a couple who considered themselves organized. There's one more piece, and it's the one that makes doing this properly worth real money, rather than just peace of mind. A surviving spouse has options with an inherited retirement account that nobody else gets. A child who inherits one is generally on a clock. The account has to be emptied within a defined number of years, which we've covered on this channel, and it lands on them as taxable income while they're in their peak earning years. A spouse is treated differently. A surviving husband or wife has choices about how to take on that account that can leave the money growing for far longer, on far better terms. But those options only exist if the account actually reaches the spouse. Which brings the whole video back to one point. If the beneficiary form sends it somewhere else, to a brother, to an estate, to a default rule, the spousal options evaporate, along with the tax treatment attached to them. So the form isn't just about who gets the money. It decides which rulebook applies to it afterwards. I'm not going to walk you through the choices, because they're genuinely technical, and the right one depends on ages and circumstances. What I want you to know is that they exist, that they're valuable, and that they're only available through a door that a form opens. Let me show you the version that keeps people awake, because it's not dramatic. It's just relentless. A couple in their late 70s. One dies in the winter. In the following 12 months, the survivor deals with a bank process for an account they weren't on, a pension provider who needs a document they can't find, an insurer who needs a certificate they've already sent twice, a tax return with a different filing status, a Medicare notice that's higher than last year, and a house that suddenly costs the same to run on one income. Every single one of those is a routine administrative process. Not one of them is a scandal. And together, arriving over a year, on a person who has just lost their partner of 5 decades, they are genuinely crushing. And here's the part that's hardest to say. The survivor usually doesn't ask for help, because the version of themselves they've been for 40 years is the person who copes. So they cope, alone, badly, and the family finds out 18 months later that something important was never claimed. That's the real cost of the afternoon nobody wanted to spend. Not money. Capacity. At the moment when there's least of it. Let me walk the 3 of them through the first year, because the paths don't separate on day 1. They separate slowly, and that's what makes it hard to see coming. All 3 households are in the same place emotionally, and in completely different places practically. Rose pays the bills, she's on the accounts, she has the list, and the day-to-day simply continues while everything else falls apart. She spends her energy on grieving, which is what that month is for. June is trying to establish what exists. She has found 2 institutions and suspects there are more. Her son has taken time off work. Nadine is fine this month. Everything looks normal. The problem hasn't surfaced yet, and won't for a while, which is the cruel part, because she'll deal with it later, alone, when everyone has gone home. Rose has notified who needed notifying and is dealing with the Social Security change. Ordinary admin, unpleasant, finite. June has found a 3rd account she didn't know about and is still waiting on a process for one she can't access. The bills have kept coming. She has been paying them out of the only account she can reach, and that account is getting thin. She hasn't told anyone because telling someone would mean admitting she can't manage. Nadine gets a letter from a plan administrator that mentions a name she hasn't heard in 30 years. Rose is through the administration and into the part that's just grief, which is where she should have been from the start. June has most of it resolved, at the cost of 6 months she will never get back, and a relationship with one of her children that got strained over a decision made in week 2. Nadine is in a conversation with her late husband's brother about an account that a form says belongs to him. Everyone in that conversation is behaving decently, and it is still one of the worst conversations of her life. And here is where the thing nobody warned any of them about arrives. All 3 now file alone rather than jointly. All 3 have lost one Social Security benefit. All 3 discover, at roughly the same time, that the tax bill went one way, while the income went the other. This part hits all 3 equally. The afternoon Clifford and Rose spent didn't prevent it. Nothing prevents it. What it changed was everything else. Whether the year that came before it was survivable, and whether the person facing it had any capacity left by the time it arrived. Now let me be honest about the other side, because I don't want to send anybody off to do something drastic tonight. Joint titling is not automatically the right answer, and I'd be doing you a disservice to imply it is. Putting an account in 2 names means both people have full access, which is the point, but it also means the account is exposed to both people's circumstances. A creditor, a lawsuit, a second marriage, a family member with a problem. Once it's joint, it's joint. In a second marriage with children from a first, this gets more delicate still, and the obvious simplification can quietly disinherit somebody you love. That is precisely the situation where a video is the wrong advisor and a person is the right one. There are also mechanisms that give a spouse access on death without making them a joint owner today. They exist, they're common, and they vary by state and by institution, which is exactly why I'm naming the concept, rather than a solution. And if your situation is simple, one marriage, shared everything, straightforward children, then honestly, most of this collapses into the free part. Read the beneficiary forms, make the list, and tell each other where it is. That's the version that applies to most people watching, and it costs nothing but an uncomfortable hour. There's one more thing, and of everything in this video, it's the piece I'd most like you to actually do, because it's the difference between a list that works and a list that only looks like it works. Being shown something once is not the same as having done it. Rose didn't just get a list from Clifford. At some point in that decade, Rose paid the bills for a month, all of them, while he sat there and didn't help. That sounds almost silly written down. It is the single most useful hour in this entire subject, and here's why. A list tells you an account exists. It doesn't tell you that the login needs a code from a phone. It doesn't tell you the mortgage is on autopay from a different account than you assumed. It doesn't tell you which of the 4 cards is the one the utilities are on. You find those things out by doing it, and only by doing it. And you want to find them out on an ordinary Tuesday, with your husband in the next room, able to answer a question. Not in February alone, at 11 at night. There's a second version of this that matters just as much, and it runs the other way. The person who handles the money should sit down once and be honest about what they don't have written anywhere. Almost always, there's something living only in their head. An arrangement with a neighbor, a small account they've been meaning to close, a reason the insurance is set up the way it is. That's the stuff that's genuinely lost. Not the big accounts, which paperwork eventually finds. The small explanations that made the system make sense. And I want to name the emotional part honestly, because it's the actual obstacle here. The person who has always handled the money often doesn't want to hand it over, and it isn't about control. It's that being the one who takes care of it has been part of who they are for 40 years, and rehearsing the handover means picturing not being there. That's a real thing to feel. It's also why this gets postponed by couples who are otherwise organized about everything. So, if you're the one who handles it, here's the reframe that might help. You are not giving up the job. You are making sure the job survives you. Which is, when you look at it properly, the last and most useful thing that competence can do. So which couple are you? You might be Bill and June, if one of you handles all of it, and the other trusts them completely. That trust is well placed, and it is not the problem. The problem is that competence isn't transferable by affection. The person who handles it has to hand over the map while they're here, and that conversation is uncomfortable precisely because it means admitting the arrangement is temporary. You might be Emmett and Nadine if you have a will and feel covered. You are covered, for the part a will covers. Go and read the beneficiary forms this week. It's free, it takes an afternoon, and it is the single highest consequence hour available to you. You might be Clifford and Rose, and if you are, you already know the strange truth of it. You will never see the benefit. Nothing will visibly happen. The disaster you prevented is invisible by definition, and nobody will thank you for it, because nobody will know what didn't occur. Most couples are Bill and June and believe they're Clifford and Rose. The test is simple and slightly brutal. If the person who handles the money vanished tomorrow, could the other one produce a list of what exists within an hour? If the answer is no, that's not a criticism of either of you. It's just a list that doesn't exist yet. So here's what to actually do, and the first part is free and takes one afternoon. 1. Make the list. Every account, every policy, every institution, every pension from every job. Not the balances. Just what exists and where. Put it somewhere you both know, and tell each other where. 2. Read every beneficiary form. Not what you remember them saying, what they currently say. Every retirement account, every policy. And name a contingent on each one because most of those lines are blank. 3. Ask one question about each significant account. If one of us died tomorrow, could the other one access this? Not inherit it eventually. Access it next week to pay a bill. Where the answer is no, that's the conversation to take to somebody licensed in your state. And 4, the hard one. Have this conversation while it is entirely hypothetical. It will be an uncomfortable hour and one of you will want to stop halfway. Do it anyway. It is the only version of this conversation that ever happens calmly. One of you is going to do this alone. That's where we started, and it's the only sentence in this video that's certain. Bill wasn't secretive. Emmett wasn't careless. He paid an attorney to be careful. The only thing Clifford and Rose did differently was spend one afternoon on it 10 years early, when there was no reason to, and nobody would have blamed them for putting it off. This isn't a loophole, and it isn't a trick. It's a list and a stack of forms nobody told you were reviewable. Take care of yourselves, and take care of each other.